Welcome back. As you can see, I am joined now by Justices Desmond and Hand. And the final case we will hear this morning is number 231195. This is Governo Law Firm versus CMBG3 Law. And we will hear first from Attorney Fleegauf.
Thank you, Your Honor. And may it please the Court. The defendants are Massachusetts lawyers who converted Governo Law Firm's property in order to start a competing law firm. At the first trial, the jury heard evidence that the defendants made $2.7 million in profits in less than 3 years, and the jury determined that a third of that, $900,000, was received on account of Governo Law Firm's property, which they had converted, and they awarded damages in that amount, $900,000. In a strongly worded decision, the Supreme Judicial Court subsequently held that the defendant's conversion could be a 93A violation. And on remand, the trial judge found that the conversion of Governo Law Firm's property indeed was an unfair and deceptive business practice. The trial judge, however, allowed the defendants to evade 93A liability by erroneously holding that that conversion caused no harm whatsoever.
Could I start with a fairly basic question, I think, although an important one? I understand your argument to be, one part of your argument to be that the judge erred in treating the case on remand as a new trial, start to finish, with respect to the 93A.
Yes, Your Honor.
And I also understand you to be arguing that that it was impermissible for the judge to approach it in that way.
Yes, Your Honor.
And I'm unclear on whether you're suggesting that there is some kind of binding precedent that says where there is a general remand order on a 93A case, that the pre-remand decision to send the case to binding determination by the jury then can't be changed later.
There's no law on that one way or the other, Your Honor. What happened here was that there was the original trial. The judge gave the case to the jury for a binding determination.
Why is the judge foreclosed from, under the remand that the SJC issued here, from going forward as he did?
Because of basic principles of res judicata, Your Honor.
But you don't say he couldn't hold a bench trial.
I'm sorry, Your Honor?
You're not saying, I see nothing in your brief that says he may not hold a bench trial.
No, certainly, Your
Okay.
Honor. That is perfectly, these decisions had to be made by somebody. But the issue is whether facts that were decided at that first trial, where it was given to the jury for a binding, not an advisory determination, whether that gets to be redone.
And it's just a timing issue in this case, because if the judge had decided to try the 93, or let me ask this, is it your position that if the judge had decided to hold for some reason and try the 93A claim after the determination of the non-93A claims?
Well, in that case, the judge would be deciding the 93A for him or herself, Your Honor.
And would or would not be bound by the determination on the conversion?
It would all depend on what the judge decided to do with respect to how to try the 93A count. If the judge said up front, this is going to be a binding determination, as he did in this case, well, then it's a binding determination. What the jury found, the facts that the jury found, are binding. The Qatar case...
So hold on. So let's assume, for the sake of discussion, that's true, that the facts that the jury found on the 93A claim were binding, as the judge articulated before the beginning of the trial.
Yes, Your Honor.
SJC said new trial.
Yes.
So new trial means new trial. New trial means it's not binding. New trial means new trial.
The SJC affirmed the conversion claim.
It did. New trial on 93A.
Yes, Your Honor. So new trial on 93A.
Okay.
If there's a new trial on 93A, there was no discussion at the SJC as to what the scope of that second trial was going to be.
There need not be one. A new trial on a 93A, I mean, it seemed like everybody was clear. I mean, it was the request of the defendants to have a new trial on the 93A, right?
Yes, Your Honor.
Okay, so you got what you asked for.
Yes.
And the judge was well within his rights to do it by way of a bench trial. There was a lot less moving parts
100%.
on the sole 93A than there was on the prior trial that had the conversion and all the other claims.
Absolutely, Your Honor. He was entitled to have a jury. He could decide it for himself, but that does not mean, and the SJC certainly did not touch upon the scope of the trial and whether or not res judicata applies. Res judicata, we went through a 2-week trial in order to determine whether or not there were any damages here, and a jury unanimously found that there were. So, you know, in the case law, if you look at the Qatar case, that's the SJC case, 433 Mass 1, Delaney, and Charles River, those cases provide that when a non-jury claim, which this is, non-jury claim is nonetheless given to the jury for a binding determination, the factual determinations are binding.
Okay, but this is never, in this circumstance, I mean, we're faced with a never before decided question, right? I mean, the question of whether it's the same when he decides to do a bench trial on remand, you say it's fine, so I'm not going to press the point. I don't think he should have been able to do it, but you haven't raised that. So he decides to have a bench trial now, even though he had a jury trial before. Obviously, if he had done this all at once, instead of going to do a bench trial after, he wouldn't be bound by anything. But in this case, he didn't do that. It went up on appeal.
He would be bound, Your Honor. If he
No,
gives,
if he had reserved to himself
I'm
the
sorry.
bench trial, then he wouldn't be bound by anything. We'd still have a jury verdict,
Yeah, yes,
but he
and
wouldn't be bound. So the question is, does it going up on appeal, the other half being affirmed, and the switch from where he said binding in the original one, does he still get to hold everything open? That's just an open question we have to figure out.
but the judge decided at the outset of this matter,
Which matter?
of the before the first trial,
Okay.
the very beginning, he said this is going to be a binding determination by the
No
jury.
question, that's undisputed.
And so what the jury found, these
But
case law.
that was before the SJC said, no good, the jury didn't have the proper instruction, new trial.
Correct.
So
But
you
that
start
doesn't
over. New
mean,
trial means new trial.
doesn't mean a new trial is to everything, Your Honor.
Trial as to 93A.
And it doesn't mean new trial as to every element of 93A. It means a new trial as to the facts the elements that were unique to 93A
Who?
that had.
Says what?
Says res judicata. Says issue preclusion. There's a reason for issue preclusion, Your Honor, is so that you have fair, even-handed, consistent results.
But isn't
so
that
you don't
exactly
have
the
to-
exception? I'm sorry, I apologize for interrupting.
No, I'm sorry, Your Honor.
Isn't that exactly the exception that 93A makes, though? That 93A is unusual, if not unique, in the fact that the judge explicitly can make different findings, is not bound. So
Absolutely.
to Judge Desmond's point, and I apologize for cutting off your answer to his question, but why couldn't the judge follow the same path?
Because in all of those cases, that's the Claremont case.
Right.
Okay, the Claremont case plainly holds that a trial judge that reserves the 93A claim for him or herself, in that instance, the judge can find facts that are inconsistent with what the jury found.
And you're saying this wasn't reserved, and therefore it's different,
Correct.
and we have to figure that out.
Correct, Your Honor.
Your time runs somewhat short. I need to understand better about FileMaker Pro databases. You say you're not contesting who owns the 8500 file. You are contesting the databases.
Yes.
My understanding is that there is some software that your firm has developed, your client's firm has developed, for indexing and searching. Is that true?
True, Your Honor.
And does it index and search not just the 8500 new file, but is there software that indexes and searches the FileMaker Pro databases?
The FileMaker Pro databases are what we call the databases, and what they do, as found by the trial judge, they are finding tools, similar to a card catalog, that allows attorneys, the attorneys in the firm, to go and find material in the actual client files more efficiently and more quickly.
In the client files?
Yes, Your Honor.
I thought the databases contained, I don't know, conventional litigation file materials such as medical records, summaries, case notes, depositions, summaries, plaintiff's occupational history, discovery issues, and expert witness information.
There was some information that was duplicated in the databases, but there was also in the client files.
I'm just trying to figure out who owns all of this stuff,
Yes,
because
Your
it
Honor.
seems to make a difference.
With
The FileMaker Pro databases include the search tool or are the search tool?
are the search tools.
And can they search the whatever new file, 8500 new file?
Yes, Your Honor.
And so they can search not just one client at a time, they can search for all cross-cutting information about Eagle's shipbuilding operations.
Exactly correct.
Or whatever it is, and maybe also what Eagle has settled things for, what judgments against Eagle looked like, all of that can be done, and that's what these FileMaker Pro databases are.
That is correct, Your Honor. And, and that was another error. Now, initially, at the end of the first trial, the trial judge said that they are not entitled to those databases. He issued a permanent injunction requiring them to delete that material.
Did you all argue below the question of when intellectual property has been changed enough or modified enough or made useful to the point where someone other than the owner of the data owns the software? Was that litigated at all?
That was not, Your Honor. That was not. The judge initially ordered that those databases be deleted. Okay? The defendants did not appeal that issue when we went up to the Supreme Judicial Court. And that decision, therefore, was final. The judge reversed himself only after remand, and he was incorrect when he did that, because what he said was they're allowed to use these databases because, as the judge found erroneously, he said that those databases were, in fact, client files. They're not client files. They don't pertain to any particular matter. They don't pertain to any particular...
They have information in them from client files, but they are not client files.
Correct, Your Honor. That is correct. And as found...
Go ahead.
It's effectively, it's a tool, a card catalog. It's a Google search. It's a way to find the materials that you want to find.
It's not a Google search because Google owns Google searches.
Fair enough.
Right? It is something developed inside your firm, but it could be like a card catalog. Maybe you made binders. Maybe instead of this, you made a binder that includes every cases, and maybe some outside information if you have it as well, about every settlement with Eagle, or how many shipbuilding places, or what dates of all their shipments were, or how much asbestos was in various things, or whatever.
Correct.
And you put it together in binders. And the question is sort of, who owns, maybe it's who owns the binders. Maybe it's, you're not saying that you own the file, the 8500.
We don't own the client files. That's clear.
And the 8500 is client files.
Yeah, well, that's what the judge found. We disagree with that, but we're not going to dispute that
but you're not
fact,
contesting it.
okay?
But the FileMaker Pro databases, you say, are yours.
Yes, Your Honor.
You created them. There's something that didn't exist before. They aren't just client files. They're a complicated compendium of something, and the software to search it, or is that?
Yes, Your Honor.
Okay.
The client files that the judge said had to be, were rightfully the client files, and they got to take them with them. Would Goodverno be able to keep copies of those files?
Yes, Your Honor. Under the ethical rules, the counsel is allowed to retain copies of the files, of the client files.
Notwithstanding they belong to the clients?
Yes, Your Honor. It's right in the rule.
Let me ask you this question. Prior to the taking of the databases, there was a negotiation about buying the firm.
Yes, Your
right?
Honor.
And they came in at 2.5, right?
I think it was lower than that. I think it's 1.5, Your Honor, but yes.
I thought they ended at 1.5. I could be mistaken, but I thought they ended at 1.5.
what
Made an offer of
2.5.
225 or something, 25, and then.
What happened was the day of, after they had already taken all of the files and put them into thumb drives and snuck them out of the file.
Before they took them, were they offering one number?
Yes, Your Honor.
And they took them and they offered a lower number?
Correct.
All right. So that strengthened, arguably, their bargaining position?
Absolutely. They knew they had put a law firm on a thumb drive and took it out with them, and then made this lowball offer.
They did that for fear that you wouldn't turn the documents over upon request?
I mean, that's what they say, Your Honor. I mean, there was a lot of back and forth on that. They took a heck of a lot more than just the client files. They took all the administrative files. They took case lists. They took everything. They took everything. In addition to those other errors of law.
Yes, your time's up, but I'm going to let you keep going for a minute.
Thank you, Your Honor.
That's apparently
Just,
what I do.
I'll get as briefly as I can. Remember that this was a conversion. They took the property of Governor Law Firm, and the statute says that anyone that has a loss of money or property can recover. And if you look at the auto flat case, the SJC auto flat case, the court held that, I'll quote it, the plain language of Section 11 and cases interpreting it, as well as the policy underlying Chapter 93A, make clear that a plaintiff who can establish that it has sustained such concrete monetary or property loss will have satisfied the actual damages element of Section 11.
What's the best case for this being property? A copy of the file that's, as I understand it, uncopyrighted intellectual property? Is that?
Yes, but it's still property, Your Honor, and the SJC.
Property for 93A?
Yes, Your Honor, and the SJC acknowledged that, I believe, in its decision. So the auto flat's directly on point. The conversion in and of itself is damages that allow us to recover under 93A. There's also this issue about the attorney's fees. We incurred attorney's fees trying to get the stuff back before there was any litigation.
Was that raised in the trial court?
I'm sorry, Your Honor?
Was that point raised in the trial court?
Absolutely it was, Your
Can you
Honor.
tell me where? Ballpark, where I can find that?
We submitted the attorney's fees, the actual invoices. There was Mr. Governor's testimony to it. There was the attorney that actually did the work. And when we submitted the requested findings of fact and rulings of law, we raised it there as well, Your Honor. And the Montañez case is directly on point. It says that pre-suit fees to address unfair deceptive business practices are recoverable as damages. So, there were 5 separate and independent legal errors that were made by this trial judge to allow the defendants to avoid 93A liability, all pertaining to whether or not a conversion of one's property, the theft of someone's property, is that an injury? And the trial judge said, no, don't worry about it. It's not an injury. That was error. And to make things worse, there's also the contempt issue. Oh, and I'm sorry, and I do need to just raise this briefly. The 93A violation, it was willful or knowing, okay? So because of that, not only is it attorney's fees, but it's also multiple damages. The amount of damage from the 93A doesn't matter in this case by statute because there was an actual judgment that entered on the conversion claim. And the statute says that the amount of the judgment for multiplying actual damages, the amount of the judgment on all claims arising out of the same and underlying transaction or occurrence, that are the actual damages to be multiplied. So that's $915,900.
Let me ask you this. You also say that and of course I'll ask opposing counsel about this, you also say that if the judge's finding that there was no profit from this were to stand, you would be entitled to your alternative damages, which is the royalty rate.
Yes, Your Honor.
Do we know what that rate is?
Yes, it's in the record. We had an expert that was prepared to testify that it was $3.2 million, I believe.
Well, but of course it would depend on how much, it would depend on how much of this was your property,
Of course.
presumably.
Certainly, Your Honor. And there would be a factual fight and there would be a dispute on that. The issue there, though, Your Honor, is that at the first trial, the trial judge said, we can't raise that because it's undisputed that there were profits that could be disgorged. So the judge said, so you're not going to be able to make that argument. But then on remand, The judge, suddenly the defendants are saying, well, wait a second, we didn't use it at all. We didn't have, there are no damages to be disgorged. The trial judge allowed the defendants to relitigate that issue. In response, we said, well, wait a second, if they're going to make that argument, then we get a reasonable royalty rate. We should be able to make that argument. The judge said no. The judge allowed them to relitigate damages, but not us.
Is it limited to just loss, or is it loss or adverse consequence?
It is some adverse effect, I believe, is the language that I've seen. Some adverse effect on the plaintiff.
Can I ask another question? The judge found that it was not your property at all. So why does the judge then go into this whole thing about how much they did or didn't use it? What difference does it make if they used it if it wasn't your property?
I have no idea, Your Honor. I don't understand what the judge did here.
The judge says that it was taken unfairly and deceptively because
Yes.
it was taken before they had clients who had moved to their
Correct,
firm
Your
at all, before they had any clients, while they weren't even a firm, while they were employed.
Yes, Your Honor.
But then he says they didn't use it.
Well, they say, he acknowledges that they use the databases. He acknowledges
He
that-
has this one statement that I wasn't sure I understood where he said, and I'll get the name wrong because I read it, I don't remember, Miyasuri might be the person's,
Sure.
that person had accessed, and I couldn't tell if he meant accessed the 8500 file or the FileMaker Pro databases
Both, Your Honor.
on behalf of clients.
Yes, Your Honor.
But that person would have been searching through materials that were not that client's material, it would be other, okay.
Correct, Your Honor. Correct.
And she used them, as I understand it, she was, I'm going to call her kind of the librarian, because even the other lawyers had to ask her for certain documents, right? Is that
That's correct.
All right. And so she had to use those documents in order to send the notices to the potential, they weren't clients at that time.
I respectfully disagree with that, Your Honor.
Didn't have to use
They received from Governor Law Firm the client files, and they received the list of the materials and the contact information, and they had the contact information anyway. They could send out those letters. They did not need to take the materials secretly in order to do that.
Did she not use them to send out the letters?
I don't know whether or not she used that or she used the materials that Governor Law Firm provided.
Are there material, oh, I'm sorry, you go ahead.
Did she have the materials before Governor sent them, whatever?
Oh, yes, Your Honor, because they stole them. They took them before they ever left the firm. Just briefly, there's also a contempt issue here, Your Honor. The judge...
Your time has expired. I mean, we have your argument on contempt.
Very good.
In the brief, but if there are further questions, it's highly complex. So I want to make sure that everybody's content. Thank you very much
Thank
for
you, Your Honor.
and for the extra time. We will hear next from Attorney Perkins.
Afternoon. May it please the court, I'm Sam Perkins, representing the defendants in this case. Let me talk first about an issue that apparently is not clear in the record, and that is the FileMaker Pro databases. There is abundant testimony about the FileMaker Pro databases as one section of electronically stored information. There's an equally large volume of testimony about the 8500 folder as an electronically stored source of information that were client files. As Mr. Fleegoff has conceded, they no longer are contesting that the 8500 folder was client files. Let me focus on the FileMaker Pro databases. FileMaker Pro is a relational database piece of software. That piece of software is owned by the Governor Law Firm. That piece of software is also owned by CMBG3. Judge Salinger's finding...
That is, it's on computers in both places.
Yes.
Okay.
In other words, CMBG3 stole no software from anyone. CMBG3 bought its own copy of FileMaker Pro in the same way that they bought their own copy of Microsoft Word and Outlook and so on. They did not take any software that was owned by Governor Law Firm. But as Judge Salinger pointed out in great detail and showed in a thought experiment, one of the ways that files were organized, client file information was organized at Governor Law Firm in order to deal with the masses of cases and the masses of individuals who were involved, thousands of plaintiffs, was to create a database in which classic client information, attorney notes, deposition summaries, medical records, settlement discussions, all of which would have been subfolders in a classic read well in a normal plaintiff's case, because that would have been impossible given the scale and the way this practice worked. They were organized into this database using FileMaker Pro software. And in that database, you could go in and you could look for a particular plaintiff and say, what are his medical records? And those would come up. You could see the same thing for attorney notes, notes on settlement, depositions, and so on.
But they were indexed in a bunch of ways, right?
So this is a relational database, Justice Rubin.
Okay,
So you
but in
can
order
choose-
to, let's just take a different example than one client's files. Suddenly, Eagle is being sued by, I don't know, someone new. And that person, I don't know, or a group of people, they worked at a series of shipyards, and Eagle was not the only supplier of asbestos, so they need to know everything about the shipyard. You could search this database because it had been indexed by shipyard. Who did that indexing?
That indexing is done by FileMaker Pro software.
No, it's done by someone typing something. So who was that?
So let me, when these lawyers put information into the file, that is into the FileMaker Pro database, for a particular plaintiff, for example, they put in the information about the name of the plaintiff, they put in who the witnesses were, what the job site was, what the medical records were, and so on. Those would be classically just like elements of a plaintiff file, but organized in this piece of software. Now, you are right
So that
in
you could
pointing out-
cross-cuttingly look at all the different
Yes.
cases.
In other words, you could go into the database and you could say, show me every single plaintiff who worked on this ship in this shipyard, right?
Right, or show every single delivery of asbestos we know of to the shipbuilder of this ship in Groton or wherever they are.
Now, the argument made by the plaintiff is that somehow the fact that Governor Law Firm chose to organize plaintiff files in this electronic way was somehow an advantage that was owned by Governor Law Firm.
It was a massive advantage to that law firm.
was
It
a
might
massive-
be its entire basis for making money.
No, I cannot.
I don't know
agree
the
with
answer to
Judge.
that, but having that experience, being the only place maybe in the world with a database like that, makes them a valuable lawyer to asbestos defendants.
So actually, Judge, I think you're conflating two different aspects of what the plaintiffs actually argued. They argued actually that the 8500 folder was what gave them that advantage. To come back to the FileMaker Pro databases, the key to this is, and now we have to look at what the ethical requirements are for turning client files.
No, we
over.
don't. I don't see that as relevant at all. It seems to me you get the client files, you shouldn't steal them before leaving, you don't have any clients, but you request the client file, you get the client file.
No, I had a different.
This is a database made up of material that's in client files, maybe elsewhere as well, but at least in client files. And it seems to me that the organization of it is what's of value. The additional tag that's been put on all these documents that says, you know, SS Bristol, that actually can really help you litigate a case. And it's not from one client, it's from 80 clients. And maybe it's from clients who aren't even at the firm anymore because they've been making this thing for so long. They're not all your clients, and we know at least one of them, whatever client Kelly kept at the old firm isn't one of your clients, or wasn't in any event. I don't understand how you can say that that's something that isn't owned by the law firm.
So I think the key here, Justice Rubin, is that when these files need to be transferred, client files need to be transferred from Governor Law Firm to CMBG3. The question becomes, how do you transfer these client files?
But that's an issue for Governor, right?
Issue for what?
That's an issue for the firm, for Governor. How should they transfer the files?
And one of the points, I think, which Judge Salinger made in his thought experiment was, if you have a certain number of plaintiff's files, which indisputably are files that should go to the new firm, how do you transfer the plaintiff's files that are contained in the FileMaker Pro database? And the answer is that and let me finish, Justice Rubin, because I think this may clear something up. You don't have the entire mass of information that is in the FileMaker Pro database transferred willy-nilly. You go by the cases that are transferring. For example, you can go plaintiff by plaintiff on this, and you can say, give me all the information classic plaintiff information like medical records, attorney notes, and so on, for this plaintiff. Where is it? How do you give it to the new firm? It only exists in the FileMaker Pro database.
Well, I guess they're going to have to hire someone to copy that stuff then. But you stole everything.
So, Justice Rubin, I'm not talking now about at the point at which my clients obtained it. The key is, had they never taken it at all, what would Governor Law Firm's obligation have been?
Actually, Judge Salinger says even the failure of GLF to turn over complete case files doesn't justify the wrongdoing.
Oh, I don't.
Okay, so then the question is, was anything that you stole their property? And I have a pretty hard time thinking that suddenly having this whole indexed database, even if it's all client file material of 500 clients, that doesn't belong to them. It's an indexed database that you say, the defendants did it. Yeah, they were employed by GFL when they indexed it. How can that not be their intellectual property? I don't get it.
I think the answer, Justice Rubin, is to come back to the question of what would need to be transferred by Governor Law Firm to the new firm in order for them to have client files, and this is the key to the ethical obligation, client files that are usable. As Judge Salinger pointed out, if you take the information that relates to all the cases that should be transferred and you print it out from the database and you turn it over, and this is actually what happened, you turn it over in the form of a 5,000 or 6,000 page Word document where all the information about individuals and their medical records and where they worked is jumbled.
Well, they may need more sophisticated software to get you the client files, but they don't have to give you how they're indexed.
They're not giving them how they're indexed. They're giving data samples.
It seems like it has property of the other side in it. Some of that is proprietary.
So
some of the searches that you're able to do with that stolen material will show you things that aren't in files of your clients. It will show you other things.
Well, that may be true, and that I think that gets
okay. So
to the
why isn't that theft of? Why isn't that theft?
It is.
Okay, so I don't understand. So it's theft of property.
Well, let's back up for just a second. Number one, what exactly were they getting? You know, I think in your mind somehow.
Who's they?
My clients. What were they getting when they took the databases? When they took the databases, the information they were getting, in my view, can be analogized to if you have an entire electronic system in which there are individual Word files, and the appeals court itself has that for the briefs you're working on, the things you're looking at, all the materials we submit to you. That's all in some sort of an indexed database with individual files.
I wish it were, but go ahead.
I mean, it's organized somehow, I have to assume, Justice Rubin, but the point is, those individual files come in and are placed in some sort of a structure for you to be able to access them.
But doesn't the firm get a vote in how they do that? Don't they get some say, rather than just taking them and saying, well, it turns out they're going to be our clients anyhow, and it turns out that you know, our client's information is what's comprised in these documents. So we're taking it. But doesn't Governo get some say? Don't they get a vote in, hey, wait a minute, we don't think you're entitled to all of that. We only think you're entitled to this, that, or the other.
Of course they get a say.
They didn't, though, right?
I think, though, Justice Dugman, we're talking about the difference between whether they get a say in turning the material over and the scope of what's turned over and the form in which they turn it over.
They get a say in that, don't they?
No, I don't think they get a say in the form, because as Judge Salinger has pointed out in his thought experiment, and by the way, these are
They
factual.
can't scan it and send you a PDF or hand you paper copies.
Let me see if I can make an analogy about you. You guys now have thousands of pages of the record in front of you, right, electronically. And it's really only usable to you, I'm assuming, if you can search it electronically as well, because you're not going to flip through 3,000 pages looking at every single page for a particular reference, right? The fact that you have an Acrobat that allows you to search for a particular word in those 3,000 pages of the record is not something that is owned by whoever the equivalent is of Governo. And that's all that we're talking about with these FileMaker Pro databases.
No, these things are indexed. It's not searching for a word. It's searching for a ship or a manufacturer or a plaintiff.
Who
With
determined how
respect,
they were going to be
Justice
indexed?
Rubin, with respect, Justice Rubin, those are words. That's how you would search for them in Word or in Adobe Acrobat or in FileMaker Pro. You would put the
No,
words. or
I would
word
go to
strings in.
Lexis and look for every case about 93A. And the way I do that is I'd use a proprietary piece of software that has indexed all these things and that could understand some of what I'm putting in, citation form and so on.
Right, but the analogy is not to the obvious huge chunk of intellectual property that Westlaw has put together. The analogy is to a set of individual documents that relate to particular individuals or cases that were being transferred.
Who determined how they were indexed? Whose idea was it to index them in a certain way?
That actually was originally done by Brian Mashura and Jennifer Carson when they worked
They
at
were working
Governo.
when they were employed by Governo?
Yes. So I think that rereading Judge Salinger's decision and his very detailed findings on how the FileMaker Pro databases were organized and how they had to be turned over in order to have them to be even remotely in any way usable by my client's firm would be helpful here, because I think there's just no question that the individual elements of information had to be turned over in a way that was readable by someone, not in 5,000 pages.
I've taken a huge amount of your time with this line of inquiry, so I'm going to give you some extra time as we did your brother.
I appreciate it, Judge. Let me make a point about what exactly happened with these jury verdicts in the first trial. You know, there's the argument, and this entire case really comes down to whether something that happened in the first trial collaterally stopped or bound Judge Salinger in the second trial. And I think that looking at the jury verdicts and looking at the instructions and looking at the verdict slip shows that, in fact, there is nothing that meets the requirements of collateral estoppel or res judicata. You know, the findings need to either say explicitly something that binds you on the 93A issues involved in the case, or by necessary implication shows that that's been found by the first juries.
What do we do with the judge's pre-trial determination that the 93A claim was going to be given to the jury for binding determination because it was inextricably entwined with the conversion claim?
I think that's really simple, Justice Hand.
Great.
Back in 2019, Judge Salinger is confronted with a case in which there are 4 or 5 common law counts and a 93A count. And they all arise out of some common nucleus of fact. And as many judges do, he said, let it all go to the jury. Fast forward to 2022, where the SJC has remanded only one case, a non-jury case, for trial. First of all,
Claim, right?
What?
One claim, do you mean?
One claim.
One claim.
one claim totally different discretionary choice at that point. I gather, Justice Rubin, you may have some issue with whether or not he had to impanel a jury for that case, given what he had decided earlier. But the fact of the matter is...
They don't raise that, yeah.
What?
They don't raise that claim.
Yeah.
So he
One way.
coupled it with the contempt and did it by way of a bench trial.
So he decided that he was going to try it to himself, which he has complete discretion to, but more importantly, there was absolutely nothing that required him to honor decisions that had been made on non-93A counts. Remember, the jury did enter a verdict on 93A. They said there was no 93A violation.
Yeah, because they were misinstructed.
Well, yes, but, read those instructions. It's a mighty close call, and there's some important characteristics to
Sure,
those
but they
instructions.
also were not misinstructed about using the moment of theft as an unfair or deceptive act.
So if I can just take a minute to talk about that issue of what the instructions were and what the SJC opinion was. Mr. Fleegoff has always seemed to feel that the conversion that the jury found had occurred, or the breach of the duty of loyalty, which the jury found had occurred, or the conspiracy, which the jury found had occurred, could all be acts that were the basis for a finding of a violation of Chapter 93A. And that is precisely what the SJC did not say. What the SJC said was, you can take the fact that the stuff was stolen into consideration when you look at the later behavior of whether it was used, because obviously if you're going to decide whether using material at the new firm was a violation of Chapter 93A, you should be entitled to consider whether or not it had been stolen from the old firm and was belonging to the old firm. And that was the error in the instructions, okay? But the SJC also made it clear that the fact that something had been stolen or was taken in a violation of the breach of duty of loyalty or through conspiracy, those acts were not 93A violations. They could be thought of by the jury, but in fact, the only behavior that was a violation of 93A was something that happened at the new firm. And I'll quote you from the decision.
I don't think, look, the judge found that they were unfair or deceptive acts or practices.
Not because they were unfair and deceptive as a 93A violation.
No, the judge found that they were unfair and deceptive acts and practices, as I read his opinion, under the statute, and then said there was no harm and therefore no violation. He did not say it wasn't unfair or deceptive. He specifically said it was.
Yes, I think he did, Judge, and I think that maybe we're giving Judge Salinger too little credit for, I think, his well-known sense of humor here, because the SJC itself pointed out that behavior that occurred during my client's employment at Governor Law Firm could not be the basis for a 93A violation. And the fact that this behavior occurred...
The judge didn't find a 93A violation, though, in the end. In the end, he didn't find a 93A violation. I'm going to, because we've gone 4 minutes, I'm going to end it there, except I want, if there are questions left from the panel, and I know there may well be. Sure? Okay. We're going to end it there. Thank you very much, both of you. It's obviously a really complicated case, and so we very much appreciate your arguments. That concludes our sitting